That's going to happen. That decision is going to be final. So we're waiting with bated breath as Kenyans to find out how that is going to see. Now, talking about the Constitution in Chapter 6, for more of this integrity question, Akisa Wandera has details in the following story.
Under the old constitution, presidential control of the institutions of governance was exercised through unregulated powers of appointment and dismissal. The president could appoint and dismiss public servants in these institutions at will. As a result, while public servants were accountable to the president, they did not think they were accountable to the public. The absence of public accountability in the exercise of power also created an environment in which corruption and impunity thrived. In view of that, there was need to establish standards for the credibility of incumbent and future leaders. Kenyans yearned to have confidence in the constitutional offices. The 2010 Constitution of Kenya, therefore, dedicated a whole chapter to ensure an effective administration that cuts across all leadership ranks. Chapter 6 of the Constitution is on leadership and integrity, and it requires state officers to be guided in their day-to-day conduct by principles of leadership and integrity, which, among other requirements, include being objective and impartial in ensuring that decisions are not influenced by nepotism, favoritism, other improper motives or corrupt practices, being selfless while rendering service solely to the public interest, demonstrating the commitment to the public interest through honesty in the execution of public duties, and the declaration of any personal interest that may conflict with public duties, and being accountable to the public for decisions and actions. Are the rules and principles provided in Chapter 6 of the Constitution adhered to by state officials? What measures have been taken by concerned bodies in ensuring that the rules are adhered to?
So the question remains, how is that interpretation to be done, especially when it comes to the law? Because at the end of the day, what rules us is the law. And at this point, I want to hand over to Michelle Ngele, who has a guest in studio, to introduce our guest and also drive this conversation. Michelle.
All right, and Michael, of course, we have in studio constitutional lawyer Harrison Kinyanjui. Thank you so much for joining us on our Dawn debate. But just a reminder of our question of the day. Remember, we're asking you whether these full integrity tests will sanitize Kenyan politics. Do you believe that these full integrity tests will sanitize Kenyan politics? That is a question we're engaging with you on our social media pages this morning. Do you believe that a full application to integrity tests will sanitize Kenyan politics? And this is what we're looking to delve into on our Dawn debate this morning. And let's pose that question to you, Kinyanjui. Do you think these integrity tests will sanitize our politics?
Thank you very much. First of all, I need to say the Constitution of 2010 brought a paradigm shift in terms of our political leadership expectations. But there is a disconnect, a disjunct between those expectations that were placed by the Constitution itself and the practical reality that we see on the ground, where you find leaders still engaged in nepotism, tribalism, corruption, selective tender grants and such like, where you find favorism, which would be against the selfless public spirit, which is expected of a true leader within Chapter 6 of the Constitution. The servant leadership that was incepted by this Constitution is yet to permeate our public leadership. Should I say from the highest echelons of our leadership, and I do not mean to disrespect our good president. I love him. But he is surrounded by people who ought to be supporting his leadership with all the good intentions that he has. You hear allegations of people connected to his office. And at one time, he threw his hands up in deep frustration. What do you expect me to do?
Right.
Really, because we have all these institutions that are supposed to be overseeing that integrity is actually adhered to in our public life. But they are not doing it. They're not living up to that expectation. So that disconnect needs to be bridged. And how do you bridge it? One, in my view, these institutions lack the capacity. For instance, we've just seen that integrated authority for checking integrity is going to screen 15,000
and 82
aspirants.
candidates. So there are many candidates.
I just imagine. No, is it practical? Is it real that you're going to actually do a good job of it? Fine, you could gloss over and quickly tell us, this is what we have come up with. So there is a chance that the 20 people who are the ultimate result of that test will feel that you actually targeted me. And it was not practical or possible that you went through, in real sense, over all these 15,000 aspirants' credentials, and then you targeted me. So there is that issue of capacity. Do they have capacity?
All right, all right. And of course, as we speak, we've seen the national rights body, the Kenya National Commission of Human Rights, move to the Supreme Court asking for an interpretation of Chapter 6. But also what KNHCR wants to find out is whether the fit and proper test for leadership should be a test of conviction and acquittal thereafter, or is it a wider scope? Because we're seeing cases of political aspirants, the likes of Anne Waiguru. She's being mentioned everywhere. But in her defense, she has not been convicted of any criminal charge. But as far as Kenyans are concerned, the last of they heard of her was when she was implicated in a multi-million shilling scandal. None of these investigative agencies have come out to tell Kenyans this is a process of investigation. So as far as Kenyans are concerned, Anne Waiguru is still connected with the multi-million shillings that were lost at the NYS. So, but then again, it's a case of innocent until proven guilty. So is this conviction test in terms of criminality the only leadership test that we need to go through?
Allow me, before I answer your question, to say with tremendous respect that we all have perceptions, and yes, I even have my own perceptions about what happened in NYS and Honorable Waiguru. The Constitution is very clear. In my view, she was a cabinet secretary. She ought to have borne the ultimate responsibility, but that's my view. Now, there is an issue here of the Leadership and Integrity Act, which stipulates that the first port of call, if you have an issue about integrity or a question about someone's corrupt conduct, the first port of call is the EACC, the Ethics and Anti-Corruption Commission. So you're supposed to go there by law. If you go and read Article 79 of the Constitution, it says that Parliament shall enact a law that should prescribe the enforcement mechanisms of this Chapter 6. And so the Leadership and Integrity Act was enacted by Parliament, which then should take care of that. So Anne Waiguru, with all due respect, goes and says, well, I'm not under investigation. In fact, I was a whistleblower, and I ended up providing the information that provided then the impetus for these investigations. Now we have suspects in court. But as a point of disclosure, let me say that I am privy to those court proceedings. But nevertheless, here we have, again, what I say, the disconnect between the reality and what is happening on the ground. But let me come back to your issue now. I have to question KNHCR, yes. Why now? Why now? We had in 2013 a case that was filed by their consortium of NGOs and civil society bodies that they wanted the Honorable Uhuru Kenyatta to be barred, together with other people, from seeking elective posts of principally the presidential seat. And what happened is that the court, through a majority bench of 5 judges, said that this is not the way to do it, number one. Number two, you have the presumption of innocence of every person against whom allegations are made under Article 51 of the Constitution. So until a court of law convicts you and you exhaust all the appeal mechanisms, then you cannot be said to have failed Chapter 6. So that is the Constitution we are stuck with. That is the law.
But the argument of the Kenya National Commission on Human Rights is that the Court of Appeal and the High Court, both of which have had such cases filed or submitted to them, have shied away from interpreting Chapter 6 of the Constitution. And that is why they've moved now to the Supreme Court, which, of course, is meant to give the final decision. But just in that legal process, how is that expected to play out?
I would fault them. I would fault them. I mean, if you want an interpretation of the Constitution, the first port of call is the High Court under Article 165 of the Constitution. What Constitution are they reading, with all due respect, seriously speaking? You cannot directly go to the Supreme Court for interpretation. This was decided in numerous number of cases. And so you expect that they should have had at least the benefit of these cases and the decisions of the Supreme Court said, you don't rush to us here. First of all, go to the High Court. Let the High Court interpret that constitution provision you want interpreted, and then if there is any dispute, it goes on appeal, and then you come to us.
But we've been debating as to the interpretation of this chapter for a while. Has the justice system also played its role in interpreting this for the Kenyans?
But the justice system, again, waits as it were for you to come. It doesn't act suo motu on its own. A judge will not wait there and say, I decide that, in fact, Michelle, you need this or the other. You have to initiate the forum, the case process. So the judiciary provides you with a forum. It provides you with the judges to hear your case. And then you have the protagonist. And unfortunately, our practice of the law here has been driven by the protagonist type of adversarial system, that you say this and he says that. And then the judge sits there, objectively listens to you, and then makes a decision. So unless someone presents the case, there is then the protagonists now coming presenting their different competing perspectives. The judges have absolutely nothing, even if they hold an opinion, they can do about that.
Right.
So you cannot fault our judiciary. And then again, I'm saying that this approach is wrong. You do not initiate your case at the apex court system. You have to follow the prescription of the law again. And the prescription of the Constitution is that if you would like an issue interpreted, go to the High Court and let the High Court interpret that. And if you're dissatisfied, go on appeal. So this process will be short at that level, I would predict.
All right.
I would predict. With all due respect, and allow me to finish at one point. And then, sadly, everybody's going to be saying, oh, you know, the judiciary is against our enforcing the integrity chapter, when in fact, the reality is that the court has declared the path you should follow. And these people have elected to disobey it. So people will be left with this bad taste in the mouth. I mean, why is the judiciary failing us? But yet, that is not the case.
Questions as to the pace that the judiciary is handling this, because at the time Kenyan was moving to the Supreme Court, lawyer Okiya Omtata, as it is, has already opposed that the case filed by Kenyan, because he says he filed a similar case at the High Court, which is yet to be completed. So the manner in which, or the speed at which the justice system is solving this issue is also wanting.
No, I don't think so. I think you could say that how you have the dispute resolved depends on two issues largely: how the parties are ready and prepared to adjudicate the case, and then secondly, the diligence with which you pursue that case, because the judges are there. And if you file what we call a certificate of urgency, even today, if you have an issue that you want to sue this manufacturer of your blouse, that they made a defective blouse, you will file what we call a certificate of urgency. It will be filed today. And believe you me, by 2 p.m., the judge will have given directions. I certify your case as urgent or not urgent, and you therefore come on this day or the other. So I do not buy into that. The judiciary, let's give it to them. Let's give to the Chief Justice. It has changed for the better. It has changed, and you can actually get your case heard quite expeditiously. And they are moving with this haste to ensure that you actually get justice. So I'm happy to say that.
They will ensure,
although I'm not a spokesperson of the judiciary,
the Constitution is upheld. Right, so let's focus on these 6 agencies that are mandated with carrying out this integrity test. And like you mentioned, there's a big gap there in terms of even the integrity of these very agencies in carrying out these integrity tests. The Commission for University Education, the DCI, and most importantly, the Ethics and Anti-Corruption Commission. We've just had a reporter, Raquel Mugai, there on the streets of Nairobi, and Kenyans are saying they even question the integrity of these commissions themselves. How are they supposed to question the recommendations given by these very commissions? Where do you think we need to begin in overhauling this entire gap?
I think also our politics is informed by money. Corruption. Because the genuine servant leadership that is envisaged by the Constitution is not encouraged in practical sense. You have a true leader there who would like to serve the people, who has a vision for the country. Take, for instance, what we have, and I'm talking about these policies, and then I'll come to the issue as to what could be done. The so-called independent candidates, majority of them, about 95 to 99%, are not truly independent candidates. A few days ago, they were rooted in a certain political party. In my view, Article 85 of the Constitution, which prescribes the provision of independent candidates in our political dispensation, is very clear. You should not belong to a political party 3 months prior to the elections. And they can argue, well, we haven't come to the election period, and therefore there is nothing that technically bars me from that. But look, it also says that your supporters should not belong to a political party. So you're going into this election as an independent candidate through dishonesty. You have not been independent. Your whole system of political practice is anchored in the political party that you are in before you lost. So what is informing your independence here is a loss.
Right.
It is not servant leadership. So automatically, in my view, all those people should be disqualified from running as independent candidates. But what do we have? Oh, these are popular candidates. We cannot sideline them. It is a political right. They have Article 38 rights to contest, and you will actually have barred a certain section of people who love them and would like to have them as their representatives. Oh, so what? So what do we elevate here?
Right.
Our law, our expectation of leadership and integrity, or these political aspirants who play chameleon in politics?
Even as we focus on the political aspirants coming in now, there are those who argue that we cannot begin carrying out integrity tests now when the question of integrity has been breached from the very top in terms of the presidency. There are those who argue that there were integrity questions with the presidency during the 2013 elections, with the ICC question. And so it would be unfair then to start doing this now. Look at the case of Mombasa Governor Hassan Joho. The question of his academic papers is being asked now, but he's already served as governor for the past 5 years. Where were these very agencies before he became governor? Where was this vetting done before he became governor? So how can we start questioning that now when he's already been in office?
Well, to be fair, the issue of Joho's academic qualifications has been in court, and it just officially concluded almost like a year ago, just about a year ago.
Right.
There were pending issues in Uganda. There were pending issues in the Mombasa High Court, in the Court of Appeal. So technically speaking, you cannot say that that is an issue that has just popped up. It's just that the media did not follow up. I know the lawyer who was involved, Mr. Gikandi. He's a very good friend of mine. And I would follow up with him because I have an interest. Exactly how will that case be decided? So that then I can learn and glean from it, so that I'm also able to be in a far better position and also to inform my clients and people who that I interact with that this is how the court has decided. Now, the issue being that if you went to Uganda and obtained that certificate from that particular university, now the question is from our own academic authority that is involved, will they go to Uganda and ask those authorities in Uganda that this is a position? I leave it to them. So having said that, nevertheless, you have a very good point. Why now? Since 2013, really, and you knew that we will be coming to this election on August 8th. I mean, this is not rocket science that you will require to have leadership and integrity issues. And then also, the cases on integrity that have flown through the court system have almost consistently stated that integrity is not a fixed issue. In other words, you do not have a clean slate that then we can always declare you to be a person of integrity throughout, even your tenure. For instance, you have governors who are right now, and your own Patrick Amimo here carried a story about a governor who has been summoned repeatedly and failed to show up before the oversight body known as the Senate. Does that person really have integrity? I'm not judging Honorable Oparanya. I'm not passing any judgment, but I'm asking, if he had integrity in 2013, can his actions now in the intervening period be said then to constitute a violation of the leadership and integrity chapter.
Right.
So it is something that is flux.
And this is what we keep asking. Is it just about academic papers and acquittal of criminal conviction? Is it a wider scope that we need to take into consideration?
Yeah, absolutely. Absolutely. For instance, if you have a look at the EACC's requirement that you do tender in your asset wealth declaration form as at the time that when you offer yourself for election. But I have to question the EACC. Do you ever scrutinize these forms again? Because the law is very clear in Section 27 of the Leadership and Integrity Act that after every 2 years in December, you are supposed to file a fresh form. Do they look at that form? And then, if we find that an MCA, a governor, a member of the National Assembly has suddenly doubled their wealth, which individual has an EACC that we know of has actually been brought to book or been stood there in the dock and say, we want you to account for your wealth. How did you amass this wealth in 4 years? For instance, again, you have heard some people in Nairobi saying that our leases were about to expire for our own residential houses. And now we realize there's a company that has been given this lease through dubious means by the Nairobi County. And a complaint is made to the CID. And indeed, it is found that the manner of extension of that lease was extremely illegal and unlawful. And this person who has taken over the lease is actually through a corrupt act. And then is a county government official or the governor then held to account. So you can see the corrupt practices that we, the ordinary people, would say that these do not pass the integrity test are not even being brought under the microscope or under the magnifying glass. And you can have those reports and everybody's going to say, oh, that issue is pending in court or that is pending in court. So what do we have? We have frustration in terms of we, the consuming Kenyan public, of the politicians' dose of politics, that we are stuck with this corrupt, inept, and completely inefficient politicians.
So in your view, this particular integrity test will not bear any fruit in terms of weeding out the corrupt officials in government? Because as we speak, we have the National Integrity Alliance, which will today present a list of about 20 names which they feel should be barred from contesting in the August polls. And I don't know how legal that is, especially whether they've gone through any court process, but can that list stand?
With respect, I don't think, just to answer your earlier question, that this will help mop up our political platform of all these inept, corrupt politicians. And I have to ask Kenyans, gosh, what do you people want us to be like in this country? If you have a corrupt leader that we here actually bought a wheelbarrow at 109,000 shillings, one wheelbarrow, I'm almost about to weep.
And same people still win in the nomination process.
Oh my God. God have mercy on this country.
Right.
Now, let me finish by saying that report, if one of those 20 people say that I was never given an audience to defend myself, and this so-called forensic scrutiny of my documents is flawed and biased, and we know corruption has found its way into those very institutions, and you find the competitor of this politician who has been disqualified may have had a hand, and maybe, peradventure, that is why they moved these people from Safari Park to this secret location, because of access by those competitors to the individuals that are actually preparing the report. I do not know. So if that report then is subjected to a judicial process, to be quashed, or to be rendered null and void, then you can see we are back in square one. And people can also argue, I will not stand to be disqualified because I have obtained a court order stopping
the same thing from happening. All right, of course, that is a very difficult situation Kenya finds itself in. Thank you so much for speaking to us. That is constitutional lawyer Harrison Kinyanjui here, trying to put into context this integrity test that the 15,082 political aspirants for the August 8th general election will have to go through. Those recommendations will have to be given to the Independent Electoral and Boundaries Commission by close of business tomorrow. Meanwhile, we're keeping an eye on that that list of 20 names by the National Integrity Alliance, which will be released today, a list of 20 political aspirants that they feel should be barred from contesting in the August 8th elections for questions of integrity. This is the Dawn Debate here on Morning Express. We'll take a short break, but do stay with us. The newsroom conversation is up next after